Good morning, everyone. Welcome to today's hearing. Today we're going to continue hearing evidence from Mr. Colin Todd, one of the expert witnesses instructed by the inquiry. So would you ask Mr. Todd to come in, please? Good morning, Mr. Todd.
Good morning,
Please sit down, make us comfortable.
Sir.
All right, all ready to continue, I hope.
Yes, sir.
Thank you very much. Yes, Mr. Millett.
Yes, Mr. Chairman, good morning, and good morning, members of the panel. Mr. Todd, good morning to you.
Good morning, sir.
Now, yesterday we were, at the very end of the day, looking at the 6th of April 2017 letter from Assistant Commissioner Dan Daly to various London boroughs. You'll recall that.
Yes, sir.
I want to go back to that subject briefly, if I may, and ask you to look at an email, LFB 401174. Now, can we look at the second email on that page, at the lower part of the screen? It's from Nicholas Coombe of London Fire, LFB,
yes.
7th of December 2016. It looks as if you've recognised this email.
Yes.
I'll read it in. Colin, this is to you. Colin, my turn for a favour. I know we've spoken about this before. You said that in the next update of PAS 79, you would put in a section on assisting external cladding systems. I'm trying to put something together to write to London boroughs about doing this when reviewing the FRA, and wondered if you had a form of words that would appear in the new PAS 79 that I could direct lift from.
Yes.
Now, we'll come to see your response in just a moment, but before we do you recall the conversation between you and Nicholas Coombe?
Yes, I recall it very well, sir.
What had occasioned it?
So, Nick, who is a good friend as well as a professional colleague, contacted me on one occasion and said that London were becoming concerned about the potential fire risk of cladding. And what did I think about that in relation to PAS 79? And so what I said to him was that we were in no rush to revise PAS 79 because, as you may remember, sir, that there were some, as I think I said yesterday, complaints would be too strong a term, but some moans, particularly from small sole traders, that they'd bought the 2012 version and they couldn't see much difference from the 2007. So we were in no rush to revise it with just one or two minor changes. So what we did was we kept a list of things that we would like to include in the new version. And so I said to Nick, I'll put that on the list of things to cover when we come to revise it. And that's what he's referring to in the first and second sentences. But then it appears that he had decided to draw the issue of cladding to the attention of the fire safety teams within the London boroughs. And so he wondered if I'd already thought of the exact wording that would possibly go in a new PAS 79 so that he could actually use them, as it were, in advance to advise his fire safety teams.
Right. When he says that he's putting something together to write to London boroughs, did you understand him to mean the fire safety teams in the LFB branches of those London boroughs, or the London boroughs themselves? For
yes,
example,
I think I spoke to him as well after his email, and when he said, he does say the London boroughs right enough, as though it's the local authorities.
That's what I assumed. Is that wrong?
But, well, yeah, it does look like that, but my recollection of the conversation was that he wanted to tell the inspecting officers in the boroughs. And I think he may just have meant the teams, because the teams are the fire safety teams are organised by boroughs.
So borough commanders.
Yes, exactly. So sometimes we don't always say London Fire Brigade. We always just talk about London, and we know what we mean. And sometimes we talk about the borough teams, and we know what we mean. So looking at it afresh, that could be the local authorities, but that was not how I took it, and I don't think that's what we discussed. But that could be wrong.
Right. Now, you said it in your last answer or two ago that the occasion of this was London becoming concerned, or LFB becoming concerned about the fire risk of cladding. What had caused the LFB to become concerned about the fire risk of cladding such that they raised it with you?
My best recollection would be, I don't know if Mr. Coombe is giving evidence to the inquiry, but my best recollection was that they'd had one or two external fires and they were concerned about some external fires, skips and the like, affecting cladding.
But the date of this is December 2016. The Shepherd's Court happened on the 19th of August 2016.
That's true. But having said that, that was spandrel panels, and Nick would have known that that wasn't really cladding. But it wasn't. I don't recall him referring to Shepherd's Court. Put it that way.
Right.
And I do recall that the impression I was left with was that they had one or two minor fires that had the potential to involve cladding, and so he wanted to do something a bit sooner rather than later and wait for past 79. That's my best recollection, sir.
Yes, thank you. Did you tell him, as he records here, that in the next update of past 79 you were intending to insert a section on external cladding systems?
Yeah, section would be too strong a term, but all I had done was put it on our list, as I explained, sir.
Yes.
And it was down as a point to raise.
Now, it looks from this email that you had already made that decision. What had prompted you to intend to insert a piece or put it on your list?
The call from Nick.
Right.
A telephone call from Nick saying, could I do something in past 79? And as I explained, sir, I said we'd put it on the list. That's his reference to speaking about it before.
I see. So this is a reference to a past conversation.
Yes.
In which you told him you were already intending.
No, not already intending.
I follow.
What I told him was, yes, he triggered it. I mean, the credit, as it were, goes to London Fire Brigade. He asked me if I could do it in PAS 79. I said yes, but not at the moment. But what I'll do is put it on the list for you.
I see. That's clear. Now, if we go to your response at the top email, you say.
Yes.
You see that you responded 2 weeks later, on
Yes.
the 21st of December 2016.
Yes.
And let's just read this together. It says, Nick, I spoke to Brian Martin and Steve Dawes about this. And Steve Dawes is a Todd person, isn't he?
He's our technical director,
Exactly.
yes.
I spoke to Brian Martin and Steve Dawes about this, and we've come up with a proposal where in a building in excess of 18 metres in height there's good reason to suspect that external cladding could readily support rapid vertical fire spread. This should be raised in the fire risk assessment as a matter for further investigation. Similarly, where damage to such cladding exposes insulation that is likely to be combustible, this should be raised as a matter for action. In any of the above circumstances, at least as an interim measure, it should be ensured that there is no reasonably foreseeable likelihood of the presence of combustible materials, for example, stored rubbish, in close proximity to the cladding. If you intend to promulgate this amongst London's finest, please give me a heads up so that we can stress the importance of it to our fire risk assessors. Equally, tell the finest that it is not in PAS 79, so absence of comments on this in an FRA does not warrant a prohibition notice. Tell them to think, educate, and inform.
Yes.
Now, just briefly on that, in the second paragraph there, London's finest, is that a reference to the LFB?
It's a reference to their inspecting officers, who I always flippantly describe to Nick as London's finest.
As opposed to the chief executives of London.
Oh, absolutely, yes. Nick would understand that we always flippantly refer to the inspecting officers of London Fire Brigade as London's finest.
And in the second line, you say our fire risk assessors. Who's the our?
Our own company and through the FIA.
I see.
It was really a flippant comment between friends. I wasn't terribly concerned, and they obviously wouldn't issue a prohibition notice. That was a flippant hyperbole. Because I always flippantly say that they overreact and will issue a prohibition notice for a cardboard box in a corridor. Obviously, they don't, and that was really just a flippant comment.
Right. Now, focusing on the first paragraph a little bit more closely, you say that where, in a building in excess of 18 metres in height, there is good reason to suspect that external cladding could readily support rapid vertical fire spread. This should be raised in the fire risk assessment. Now, when you wrote that, were you assuming that the reasonably competent fire risk assessor would know enough about cladding or cladding systems to have, quotes, good reason to suspect that it could readily support external fire spread?
There may be circumstances where they might have that reason, but particularly, I know I said similarly where damage, but to explain it in a little more detail, if it would have helped, sir. We were slightly at a loss to know what we could say about it that would be of much use to fire risk assessors, both Nick and myself. So I remember going upstairs, speaking to our technical director, and his view was, well, they won't know, so what are you actually going to say? And I said, why don't we have a conference call with Brian Martin at MHCLG, who I think it's no secret is also a personal friend, and let's see if we can put our heads together and come up with something a bit hand-waving that we could keep in mind for the future PAS 79. And I stuck that email on the PAS 79 file, and without really having given an awful lot of thought to the detail as to what we would ultimately say. What we'd spoken about was if, for example, and this would be a very good example, you had polystyrene insulation rendered with some sort of rendering, it often gets damaged where a vehicle has backed into it or whatever damage mechanically might be caused. So then you've got exposed combustible materials, and that would be something that was very visually obvious to fire risk assessors. And I think you saw that, sir, in the competence standard yesterday, that visual signs of physical damage would be something that a fire risk assessor ought to be aware of. But we had nothing probably more in mind in terms of the first sentence as to what specifically they might look for. So we kind of filed it away for think about it on another day.
Forgive me, but the words in the first line,
yes,
at the end of the first line, follow a colon, which comes after the words, we have come up with a proposal. And then what follows after the colon, proposal colon,
yes.
Am I right in thinking that that was the form of words with which you were content, which should be disseminated among borough commanders?
Yes, absolutely.
Yes. So coming back to the question, given that form of words at that time, were you making an assumption that the reasonably competent fire risk assessor would know enough about cladding to have, quotes, good reason to suspect that external cladding could readily support rapid vertical fire spread?
I think we took the view we'd probably have to give them some further detailed guidance, because in many cases they wouldn't really, you can't tell visually, which is why we wrung our hands as to what we could usefully say, and why I involved two colleagues to see if we could come up with anything.
Without that further detailed guidance, I'll come back to that in just a second, but without it, at that time, late 2016, what were the basic indications in a cladding system that any competent fire risk assessor would recognise as a candidate for rapid vertical fire spread?
Yes, that's a very good question, sir. I'm not sure I have a commensurately good answer. And I'm not sure that we'd thought through the detail of it in that sort of analytical detail. What would they look for? Well, visual damage is an obvious point, but I know you're going to say that's more the second sentence. It's very difficult, to be honest. I don't think we had anything specific in mind because we knew how difficult it was.
Thank you. And by further investigation,
Yes.
As you say, matter for further investigation. Did you mean further investigation by the fire risk assessor or further investigation by the responsible person?
No, further investigation by someone who had competence in that area, which the fire risk assessor wouldn't.
Yes, I see.
And that remains the philosophy today.
So how would it work? The fire risk assessor would say, this needs further investigation. The responsible person would engage a specialist.
Yes.
The specialist would report, and then the fire risk assessor would assess based on that report.
That would be the formality of it. And,
yes.
and we're really only today getting round to that with the publication of PAS 9980 and its interface with PAS 79,
right,
where we're now telling risk assessors that you need to get someone who has particular competence in external wall construction, and the intention is that they would carry out an appraisal to this new PAS 9980, but that wouldn't be the typical fire risk assessor that does that.
Yes, thank you. Now, can I turn to a completely different topic?
Before we leave this document, just help me, if you would, with one thing.
Certainly, sir.
We see yet again the reference to buildings in excess of 18 metres in height. To the layman, it appears an illogical point to make here because, I mean, let's take a building of 10 metres in height, 10 stories in height, let's say it's 30 metres. Or
yes.
The potential cladding fires are just as important, aren't they?
Yes, it says in excess of 18 metres.
Yes,
sir.
but why limit it to...
Oh, why not 15 metres, you mean?
Well, no height restriction.
No height restriction. That was to, bear in mind that we'd had the conversation with Brian Martin, that was to parallel this with approved document B and the guidance under the building regulations, which you may have already heard evidence, sir, has this 18-metre cut-off. The 18-metre cut-off has that been explained to you, its background, sir?
Well, a certain amount has, and I'm not inviting you to go into that, at least at this stage.
It's very quick.
Well, it may be, but that's
okay.
My point is, why put in any height? I mean...
only because
From the fire risk assessor's point of view, surely what the responsible person needs to know is the external wall at risk of going up in flames?
Yes, that's correct. But approved document B would have imposed much more stringent recommendations for buildings over 18 metres, arbitrary though that height might be. And it is arbitrary now, sir. It wasn't at one time, but it is arbitrary now. And so under approved document B, technically, although people will dispute this and they will say you should go back to the functional requirement, but the practicality is that designers would not be particularly concerned in relation to the fire performance of external wall construction in buildings less than 18 metres. So it would be a disconnect, a mismatch, if someone builds a new building and they have cladding which might not have as good performance in terms of fire as it would have if the building was over 18 metres, and then along comes a risk assessor and says, oh, I don't like the look of that, but it's just been built in accordance with the guidance under building regulations. Yeah. Do you see that point, sir?
I do see the point, but I would have thought that the responsible person might need to know if there was a risk of fire.
Yes, that's true, but it was generally held that the risk, you probably know, sir, this is very current within the last few days, that the government position is slightly modifying on that in relation to buildings under 18 metres. But what people need to understand is nothing happens at 17.999 metres that changes things such that if it's 18.001 metres is different. It's just an arbitrary limit based on historical considerations.
Yeah. All right. Well, thank you very much. I've disrupted Mr. Millett.
Was that enough of...
Yeah, that's plenty. Thank you very much.
Okay, thank you.
But I'm sorry, Mr. Millett, I completely interrupted your line of questioning.
But it was all very useful.
Back to it.
Not at all. FRA actions is the topic I want to go to next, and I want to start within that topic with the subtopic timescales. And I want to look at the FRA action plans that we have. Can we start with PAS 79, please, at CTA 703, page 59, and I want, within that page, please, to look at clause 19, little Roman 2, on the left-hand side. You can see it there. Formulation of an action plan is the title. And on the left-hand side, at the top of the column, it says, under Little Roman 2, in formulating an action plan for premises in which the fire risk has been assessed as unacceptably high, the analytical approach to fire risk assessment permits backtracking to determine whether, in effect, the problem arises from inadequate fire prevention, i.e. inadequate means for control or elimination of fire hazards, inadequate fire protection, e.g. unsatisfactory means of escape or fire warning systems, shortcomings in fire safety management, and we'll come back to that, or a combination of these. Now, looking at page 73 of your report, your main report, if we can go to that, please, just to remind ourselves, it's CTA 6011, CTA 6011, page 73. If you go to paragraph 7.41, which we looked at yesterday,
Yes.
You can see that you set out the matters there to be considered by the fire risk assessor with regard to management of fire safety,
Yes.
as you say. And that requires detailed and sustained interrogation, doesn't it, of the responsible person, the client?
Detailed and sustained. It needs a discussion.
It needs a discussion.
Yes.
I mean, none of those bullet points would be evident to the fire risk assessor unless he talked to a person.
That is correct.
Yes. And that's also the case, isn't it, in relation to the policies, structures, arrangements translated into action in each building?
Yes.
Yes. How in practice would a fire risk assessor go about the task of having that discussion?
Okay. So if you've never been to the building before and never dealt with the client before, you would want to sit down with a representative of the responsible person. Bearing in mind the responsible person will be a body corporate normally. You sit down and talk to them about all of these things. You might ask to see some samples of records, but you would basically, you couldn't complete the PAS 79 pro forma, if that's the pro forma you'd be going to use, without having had that discussion. If it was a client that you were used to dealing with and you knew, for example, what their policies were on testing and servicing of fire protection measures, you might well check with them, is everything the same as before? Are we still arranging for 6-monthly servicing of fire alarm systems and so on? But you would probably need much less of a discussion because you already had the working relationship with the client.
Yeah. Now, so does that tell us that, for example, looking at your second bullet point there, structure for management of fire safety,
Yes.
That the fire risk assessor would have a conversation with the responsible person or a representative of the responsible person about the structure within the organisation for the management of fire safety?
Yes, they wouldn't do a full fire safety management audit because, in fact, there was a completely different PAS for that. It's now a British standard. But you'd want to know, you say, yesterday, sir, we talked about what I called the competent assistant under Article 18. Well, you can't complete the PAS 79 template unless you have identified for yourself who the competent assistant is. To understand who the competent assistant is, you'd have to understand something about how they went about managing fire safety, perhaps even health and safety in the round.
Exactly. Now, what would happen if during the course of the investigation of the structure for management of fire safety with the competent assistant told the fire risk assessor that the structure for management of fire safety depended on a third person for funding FRA actions?
I don't think the fire risk assessor could you just put some legs on that with an example, please?
Yes, of course. Supposing the competent assistant told the fire risk assessor that it was all very well giving them advice about what actions to carry out by way of remedy, but the fire risk assessor should be aware that there was only a limited pot of money available. What would the fire risk assessor do or say?
He would tend to take the view that that wasn't his problem as to how they funded the recommendations. That would be a matter for the organisation themselves, because the fire risk assessor can't be influenced by the ability of the organisation to pay. And that would be outside the meaning of reasonably practicable. The measures that the fire risk assessor must come up with must be reasonably practicable. And I've no doubt the inquiry is familiar with the meaning of that, about cost, time and effort versus risk, and the foundation for that in Edwards versus National Coal Board. But the subtle point about reasonably practicable is that the cost has to take into account only the risk, not the ability of the duty holder to pay.
Yes. Now, in fact, you cite the Edwards case. In fact, I think PAS 79 has some guidance on this. And I just want to look at that with you. Can we go back to PAS 79 again, please, and look at page 59, 703, 59, Roman 3. If you look at Roman 3,
yes.
It says the action plan is an inventory of actions normally prioritised and time-restrained to devise, maintain or improve controls. First, what does time-restrained mean? Does that mean time-limited?
It means that you should give the duty holder some form of time within which, in the opinion of the fire risk assessor, the work should be completed.
And was that because a timescale would be some kind of indication of the gravity of the cure action needed?
Yes, but not always, sir. Could I give an example that might help the chairman?
Yes.
Imagine that you carry out, we talked about plant rooms yesterday being within the scope. Imagine if the fire risk assessor goes into a plant room and he finds some rubbish that has been left there by contractors, combustible rubbish. That's not a huge risk, because what's going to ignite it? The boiler blowing up, perhaps, arson, whatever. It's not a huge risk. It is not a grave issue, but you would put it down for immediate action, not because if you don't, someone's going to die. It's because why would you wait 3 months to move some boxes? So sometimes the recommended time relates to the ease. On the other hand, if you found a hotel with a fire alarm system on its last legs, you would think that was a very important matter, but there'd be no point in saying, put in a new fire alarm system immediately, because it would have to go out to tender, specifications would have to be drawn up. So there's no point in saying a new system immediately, because it can't be done.
Yes, I follow. Now let's look at little Roman 7 on the same page, please. Just cast your eye to the right-hand side of the screen. It says this: it is normally appropriate to allocate priorities to each measure recommended in the action plan to reflect the urgency of the measure as determined in the fire risk assessment. This might, however, be unnecessary if, for example, most of the recommended measures are minor in nature and will be implemented in the short term in any case.
Yes.
That's your rubbish example, I think. Would the fire risk assessor normally take account of expense and complexity of the remedial action when recommending a priority and time limit? Or would the fire risk assessor normally simply consider the risk to life safety?
No, they would have to consider the cost and the reasonable practicability, which then brings the whole lot together with cost and risk.
I see. And if you look at page 59 at on the right, left-hand side again, at little Roman 4, if we just go back to that, I think we'll need to thank you, yes.
Yes.
The whole of it. It says this: the adequacy of the action plan needs to be tested, at least in the mind of the fire risk assessor, before it's finalised. At that stage, it is appropriate to consider the following questions, and then there are 5 questions set out. Will the revised controls lead to tolerable fire risk levels? Are new hazards created? And then C, have the most cost-effective solutions been chosen? And I don't think we need D and E for the moment, at least. So have the most cost-effective solutions been chosen? I would suggest, and help me with this, that doesn't mean that an otherwise urgent remedial action should get a longer period for cure for financial reasons.
Oh, absolutely not.
No, thank you. Now, let's look at Mr. States.
Sorry, can I just elaborate on that, sir? Often there's more than one way of skinning a cat. So you can achieve a reduction in risk by a number of different methods. And that point is subtly different from the point you're making. The point you're making is absolutely correct, sir, that you can't take into account the fact that they haven't got any money.
No.
But this is actually making a slightly different point. This is basically saying, if there are a number of different solutions, have you thought of which solution would be the most cost-effective in terms of reducing the risk at the least cost?
Yes. Now let's look at Mr. Stokes's timescales in his action plans for Grenfell Tower. And I want just to look at the December 2010 and the November 2012. Can we start with the 2010 at CST 403165, please? And let's go to page 1. And there you'll see the date, 29th December 2010, and the priority timescales, a quarter of the way down your screen, Mr. Todd. Can you see?
Yes, sir.
Timescales high, 2 to 3 weeks, medium, 1 to 2 months, low, 3 to 6 months.
Yes.
And then perhaps we can have at the same time on the screen the 20th of November 2012 action plan, CST 403083, also page 1, same place on the page. If you cast your eye to the right-hand side of the screen, priority timescales, high 2 to 3 weeks, medium 2 to 3 months, low 6 to 12 months.
Yes.
You can compare the two. You've got 2 to 3 weeks remains the same, but the medium is now gone out. Instead of 1 to 2 months, it's 2 to 3 months. And
Yes.
the low, instead of 3 to 6 months, is now 6 to 12 months. Were those timescales in either of those risk assessments recommended by any government guidance or by any version of PAS 79?
No, not at all.
So the timescales were left to the decision of the individual fire risk assessor on a case-by-case basis. Is that the way?
Yes, there is something in PAS 79 that says there's no unique way of designating priorities and timescales, and find something that works around how the company is organised, and take that into account. It's unfortunate that what Mr. Stokes has done, and many would do this, he's actually conflated the priority in terms of how much risk is created and the timescale. Personally, in our own practice and in many fire risk assessors' risk assessments, they separate the two. So if you take my rubbish point, that would be a low priority, but an immediate timescale, because there's no point in waiting, but it's not a high risk. If you take my fire detection point, the hotel with the fire detection system on its last legs, that might be a very high priority, but the timescale might be longer than moving the boxes simply because of what can be achieved.
When you say he's conflated them, do you mean that he should have a priority scale for the risk and a separate for completion?
I think that makes a better job of it, sir, yes.
Can you help us? Was there any government guidance or any other kind of document which would have prompted a change in the timescales between December 2010 and November 2012 for the medium and low categories?
No, I can't think of anything, sir.
No. No, because Mr. Stokes told us that he would have altered them because of relevant guidance that was available at the time. Can you help us as to whether that's correct?
Did he elaborate on that at all?
No.
So the CLG guides have been the same since 2006. The LGA guide, I don't think. The LGA guide came out between 2010 and 2012.
Yes, it did.
But I think in terms of timescales, we certainly referred to frequencies of fire risk assessments. I don't think, sir, we gave any indication of timescales for work. So I don't think he can be talking about the LGA guide. PAS 79 came out, I think you told me, sir, it was August 2012, but I don't think we suggested.
No.
So I can't think of what he had in mind.
Now, can we go to his 2014 FRA action plan at CST 403177, again, page 1. This is dated the 17th of October 2014, and you see in the same place on the screen priority timescales: high 2 to 3 weeks, medium 2 to 3 months, low 6 to 12 months. So, like the November 2012 FRA action plan, but this time he's added some words in brackets after the low to start to action any works. Now, Mr. Stokes' evidence was that the newly added qualification here to start any action, to action any works, applied to all of the timescales listed, and that meant, and I'm paraphrasing, that if possible, the work should be completed within the timescale, but if that wasn't possible, for example, for financial reasons, then the work had to be started within the timescale he set out, but not necessarily finished. I'm paraphrasing his evidence at day 137, page 40, lines 3 to 22 there. Now,
yes,
that was his evidence. Is that qualification, or rather liberty, in favour of the responsible person, to be found in any government guidance or PAS 79 at the time, October 2014?
No. Pragmatically, it wouldn't really entirely make sense to apply, if that's intended, if that qualification is intended to apply across the three, which would seem intuitive. It wouldn't make sense to apply that to everything. So if you take my fire detection system again, sir, then you might say that the time to let's say it were 3 months. The fire risk assessor would not know what the installation project, how long that would take. So, but he would know that you'd have to write a specification, put it out to tender, evaluate tenders. So for something that involved major capital works, you might say you need to have got this rolling and be starting the work within a time scale. You might do it for certain things like that. But if you take if you go to the other extreme and take my boxes, it wouldn't make any sense to say that you start moving the boxes in a specific time period. It would be completed within a time period.
Yeah, I see. Now, that distinction you've just drawn, sitting there today, is it one that one can find in any government guidance or in any PAS or even the competence criteria?
Do you know, I would need to look up PAS 79 to see whether under prioritisation, and I don't know if you want to go to that section, sir. The reason I'm hesitating is within our own fire risk assessments, we actually make this distinction clear that where there's major capital works involved, the time scale is to actually make sure that you have progressed it. And then the installation time period will be what the installation time period is.
Yeah, yes, I mean the approach that you've just identified, you've helpfully told us, was one that you would, you say, have within our own fire risk assessments. Do I take it from that those are assessments that you would carry out professionally for clients?
My company would carry out, sir. Yes.
Was it a practice commonly adopted by fire risk assessors at the time, 2014 and thereafter?
No, I wouldn't say that it was. I think people tended to adopt their own, and PAS 79 facilitated this. They adopted their own rationale and designation for priorities and timescales. Right. And I think PAS 79 actually says there is no unique way of doing it. And I think we give some examples actually in PAS 79 of different ways you could go about it.
Do you agree that the consequence of this caveat to start to action any works being applied across the board meant that actions, even high priority actions, could be left to continue uncompleted indefinitely?
I'm not sure about the word indefinitely, because if you start the work at a particular point in time, then it won't be entirely indefinite for completion. But yes, I would agree that this would not tie you down terribly well in terms of getting the work done.
Yes, I mean, was what Mr. Stokes did, namely to say to start to action any works without regard to whether they were major capital works.
Yes, that's too much of a blanket statement.
It's too much of a blanket statement. Is it something that no competent fire risk assessor would have adopted?
I think it would be an unusual thing to adopt, sir.
Right. Now, Carl Stokes told us that it was for Janice Ray at the TMO to judge the completion date. Would you expect a reasonably competent fire risk assessor to leave that decision to the client, the competent assistant within the responsible person, without advising that person about the risks of not completing the remedial actions within the recommended timescale?
No, I think some yardstick on the level of risk. This is why I suggested that it's much better to specify the level of risk and the timescale and separate the two out so that people have an understanding of how much risk there is from the situation remaining unremediated.
Yes. Well, let's look at a different example, a different building, Adair Tower. Can we go, please, to CST 409046?
Sorry, before we leave this document, Mr. Willett, can I just ask, in a way, this approach that we see in the document on the screen is rather mechanistic, isn't it? Because you've got high, medium and low with prescriptive periods in. One might have thought that a better approach would be to assess each individual element in the pro forma and describe for the benefit of the client, as you say, how important, how great the risk is and how quickly it needs to be remedied.
Yes, that's correct, sir. If you have the two, the priority and the timescale, then the client has a better handle on how urgent these things are and how much they matter, as it were.
And you don't need to force them into one of the categories because you don't need to have categories, do you?
I think the categories are helpful. I think it's probably enough to separate the two. So my rubbish would be a priority. Well, the way we would, my own company would do it would be that we would regard that as a 3, as it were. Which would mean this is just good practice, but it's probably not a breach, arguably not a breach of legislation, and it's unlikely to result in death or serious injury. So that gives people a handle on how important it is, but then we'd have a separate timescale, as I explained, sir. Whereas the detection system in the hotel, we might say it's liable to break down at any minute. That's a really high risk. So you'll need to focus on this, but get weaving on it within 3 months or whatever, or maybe even get weaving on starting to write your specs immediately.
Yes, thank you very much.
Yes, thank you. Adair Tower, CST 409046, if we can just go to that, please. This is at page 1 of that document, as you can see, the fire risk assessment by Mr. Stokes for Adair Tower, dated the 11th of November 2015. And if we go to page 5 at the top of that page, you can see item 12I, where the priority is given as strong advice. And this is about flat entrance doors under the identified risk or hazard.
Yes.
And it says the flat entrance doors in this building have rising butt hinges on most of them. A good percentage of the flat entrance doors in this building are to be changed for new doors, item 12C above. I'd recommend that any flat entrance doors in this building that do not have self-closing devices fitted to them have self-closing devices fitted. And then the TMO accepted that recommendation. Now, I want to ask you about strong advice. Strong advice wasn't defined in the priority timescales on page 1. Was it a priority category known to the fire risk assessment trade at all?
The problem is, sir, everybody did their own thing on priorities. If you're having a high, medium and low, it's somewhat anomalous to then have a strong advice, because I'm not sure whether strong advice is more important than high or less important than high. I presume it meant something to Janice Ray or the TMO, but as I say, we see all sorts of weird and wonderful methods of prioritisation and expression of priority, but that does seem a bit anomalous with high, medium and low.
Yes, I mean, I'm assuming on that basis it didn't have any basis in any published guidance.
No, it's not a term. I mean, it almost implies that it's less mandatory to the extent that anything can be mandatory in a fire risk assessment because it's all recommendations. It almost implies it's outside the prioritisation scheme and that it's not. It's just a strong recommendation rather than a must-have. But I may be reading something into it that was not understood, not the understood meaning between Carl Stokes and Janice Ray.
Yes. Is strong advice a type of priority level that you would expect a reasonably competent fire risk assessor to attribute to the installation of self-closing devices on flat entrance doors in an action plan?
They did have a form of self-closing device in the form of rising butt hinges, but rising butt hinges are a really, really poor way of causing a door to self-close. They would have been accepted under the building regulations in the 60s and the early 70s, when regulations were prescriptive, and the regulations specifically said that flat entrance doors could be self-closing by virtue of rising butt hinges. But then in later versions and in guidance, we would regard rising butt hinges as an unacceptable method of closing a flat entrance door.
Indeed. The LGA guidance strongly deprecated.
Yeah, yes, we do. Yeah.
Yes. And therefore I ask the question, is strong advice, which you describe as an anomalous description, the type of priority level that you would expect a reasonably competent fire risk assessor to attribute to the installation of self-closing devices on flat entrance doors?
I'd probably regard that as a high priority because personally I would treat a rising butt hinge as nothing.
Yes. So we overspoke, I'm afraid. I was finishing.
I'm sorry, sir.
You started your answer. But do I take it that it is the gist of what you've just told us, that saying strong advice was not the type of priority level that you would expect a reasonably competent fire risk assessor to attribute to the installation of self-closing devices?
Yeah, my difficulty is I don't know what he meant by that.
Right.
I genuinely don't know, sir.
Right. Now, let's just look at some contemporaneous material. Can we go, please, to CST 3026445 at page 1, bottom of that page, and over to page 2. This is an email chain of the 20th of November 2015. At the very bottom of page 1, it's from Barbara Matthews to Janice Ray. And if we go to the top of page 2, you can see that Barbara Matthews says, well, please see attached and attached from Carl. And then at the bottom, the top of page 2, Carl from Barbara. Yesterday when we met, we agreed high priority items are stated as such due to the legal or regulatory requirement to undertake the action. As this is not the case with retrofitting self-closers, I'm not sure why you would be stating it as a high priority. We've agreed internally that we will arrange for a programme of fitting self-closers on existing doors to be undertaken quickly. However, as we are unable to enforce this for leaseholders, we will be unable to action the as currently described. Our programme will concentrate on tenants' doors and will strongly advise leaseholders to follow suit. We do not want to be in a position with the LFB that they can issue a deficiency notice for all doors, as we would be unable to fully action this. We would be giving the fitting of self-closers where we can a high priority, and to note that all new doors fitted would have self-closers fitted anyway. Hopefully you can now at least downgrade this priority to a medium, if not low. Now, I've shown you that.
There's quite a lot in there, isn't there?
Sorry?
There's quite a lot in there.
There's quite a lot in that. Now, if we go back to page 1, we can see his reply. If we just go back to page 1, please. He comes back at the very top of the page to Barbara Matthews on the 20th of November. And there's an email below that says, Carl, apologies, I should have read Janice's first email to me that proposed you amend high to read strongly advised, which I agree would be better. Presumably this would have no colour. You see that? And then he responds at the top of the page, Barbara, correct, please see attached as sent back to Janice, now called item 12I. And 12I was what we were looking at before. Now, Mr. Stokes agreed in his evidence that that appeared to show that the TMO had placed pressure on him to downgrade the action from high to strong advice. And for our purposes, that was at day 138, at page 201, lines 12 to 14. Now, if, in fact, it was the case that Carl Stokes, in downgrading the FRA action on self-closers to strong advice, was doing so under pressure from the TMO, would that have been normal in the trade?
No, sir. And I think that possibly helps with an insight into your previous questions to me about the meaning of strong advice, because this would imply to me that strong advice was, in fact, something less than high priority. So that helps us a little bit, doesn't it?
You tell me it does, then it does.
Yes, it does.
Tell me, would it have been normal in the trade, is my question.
For the risk assessor to bend, as it were, to the will of the client, or for the client to try to impose something on the risk assessor?
Yes.
Which?
Well, to bend to the will of the client is the premise.
To bend to the will of the client. It's not unknown, particularly for very small firms that are sole traders, to listen too much to the will of the client. I have come across that in some circumstances. It's wrong, but it does sometimes happen.
It's wrong, but it sometimes happens.
Quite rarely, I hope.
Would you expect a reasonably competent fire risk assessor to bend to the will of the client, assuming that that is in fact what happened?
They may have competence in risk assessment, but they shouldn't bend to the will of the client. They should stick by their guns if that's what they believe.
Yes.
Otherwise, they shouldn't have written it in the first place.
Thank you. Now, can we then turn to another subtopic, which is review of the FRA? Can we start with PAS 79, please? So CTA 703, page 62. And on that page, we'll see recommendations. And under 20.2, it says, let me just scroll, thank you. When the fire risk assessment is reviewed, it should be confirmed whether work recommended in the original action plan has been carried out.
Yes.
And if you look at the commentary on clause 20, at Little Roman 5, I think you need to go back to the previous page and look at the right-hand column at the top. You can see under Little Roman 5, it says, when the fire risk assessment is reviewed, consideration needs to be given to the extent to which the original action plan has been implemented. Work that has not been completed needs to be identified. That last sentence is important. On the basis of this guidance, where some or all of the actions have not been undertaken, would you expect that fact to be expressly documented in the next fire risk assessment for that building?
And separately identified, do you mean from new recommendations?
Yes.
Yeah, our own practice would do that. I'm not sure that everybody would. They might well simply repeat it again sometimes.
Yes.
I prefer personally to point out that this is outstanding from a previous fire risk assessment, because it highlights it better to the client that work has not been completed. This is not something new. But not everybody would do that.
Well, I'm puzzled by that, because that would rather imply an ambiguity here. Does this mean, or is it supposed to be taken as meaning, not simply that there was outstanding work, but the fact that it had not been completed itself needs to be identified?
Needs to be separately identified.
Well, the fact that work has not been completed needs to be identified.
Yes, I think there's some ambiguity in that sentence, reading it, if I'm honest.
But would you also expect a competent, reasonably competent fire risk assessor to identify the past due date? In other words, the date his previous fire risk assessment had placed on the completion of that item.
So that it would be identified that it hadn't been completed in time.
Correct.
Yeah. I personally would like to see that. I'm not sure that all fire risk assessors would actually point out that the time scale had passed. I think some might well repeat it as a almost as though it were a new item, but it's much more helpful to separately identify it.
Yes, and one can see that there are obviously variations in the practice. My question really is, would it be unreasonably incompetent for a fire risk assessor not specifically to identify actions that were to have been completed but had not been?
But had not been completed.
Yeah.
Not sure it affects the competence of the fire risk assessor to carry out a fire risk assessment, but it's less helpful than it might be, certainly.
All right. Would it fall? If you took that approach, would that fall below the prevailing standards of competence?
No, I wouldn't go that far, but
Right.
But you do need to monitor it, because there comes a point, sir, when if you keep finding the same thing, risk assessment after risk assessment after risk assessment, then for your own liability alone, you would want to, and we've had to do this on occasions, escalate it to some higher level and point out that we keep telling you this and you're doing nothing about it. And that's the ultimate sanction, as it were.
Now, it was I who suggested the potential ambiguity, but it may be cured if we look at the template in Annex E. If we go to page 112 of this document,
Yes.
Some 50 pages away, we can see here, it says, this is page 112. For some reason it's taking a little time to come up.
I might be able to help you from memory if
I think we should have the
if the technology is not going to
well, no,
do as you wish.
We'll have the document.
Okay.
CTA 703, page 112. Oh. I think that, I'm told, Mr. Chairman, the transcript stopped working as well.
Well, let's just see if the... Yes.
Which it has.
Well, I've asked it to refresh, and it's telling me the site can't be reached.
Right.
Would it be sensible to take an early break?
I think it would be a yes.
Yeah. We wouldn't normally have a break quite so soon, Mr. Todd, but
Yes,
I think
sir.
in the circumstances, we'll have the morning break now. We'll come back at 11:15, assuming that the technology is back on track by then. If not, we'll have to wait a bit longer, and hope we can continue.
Certainly,
And
sir.
again, please don't discuss your evidence with anyone.
Of course, sir. Thank you, sir.
Thank you very much. Well, it looks like the transcript's back on, but we'll still have the break. 11:15, please. Thank you. Would you ask Mr. Todd to come back in, please?
Thank you.
Right, Mr. Todd. Yes, sit down.
Thank you,
of
sir.
course. Sorry, we kept you waiting longer than I said we would, but there were reasons for that. Anyway, I think we're now up and running. We seem to have the transcript, and we'll see if we get the documents.
Yes, thank you very much, Mr. Chairman. Mr. Todd, I was going to take you, please, if we can, to CTA 703, page 112, 112. Here we can see within Annex E to PAS 79 2012 edition, fire risk assessment, action on previous action plan. And can you see that underneath that it says, have all previous recommendations been satisfactorily addressed?
Yes.
Box for yes, box for no, and then brief details of recommendations not yet implemented.
Yes.
Would you expect to see that box in a fire risk assessment or in a related action plan?
Not always. This is an informative annex, as I think we discussed before, sir. So some people have their own versions, some people have a completely different version while still following the process of PAS 79. So people tend to lay out the information they want to impart in different ways. So sometimes you'd see that, sometimes you wouldn't.
Well, let's just take this in stages. You say sometimes you would, sometimes you wouldn't. That may be the practice in the trade.
Yes, that's what I meant, sir. Sorry.
Yes. No, I understand. Let's just take it in stages. What would be the importance of including this information in the FRA action plan?
To make sure that there was nothing missed from the previous fire risk assessment, and to make sure that things were progressing along properly.
Yeah. And would you agree that by including this box, it would show that the fire risk assessor had turned their minds to whether the previous recommendations had been satisfactorily addressed, and if not, which ones hadn't and why not?
Yeah, that's precisely the intention, sir, yes.
And also to assist the fire risk assessor to identify any shortcomings in the fire safety management system or other shortcomings in the responsible person's ability to mitigate fire safety.
Yes, it would have that spin-off benefit.
Yes. I mean, so why was it a matter of taste or individual practice as to whether or not this might or might not have been in an action plan? Surely this was essential.
Well, the problem is there is no statutory form of imparting the findings, the significant findings of a fire risk assessment. So the Article 9 duty under the Fire Safety Order is to record significant findings. My view is, and I think, again, you and I are ad idem, sir, that this is quite significant. Others might take a different view. The problem is significant findings are not addressed. The minimum prerequisites within the order itself, as I'm sure you're aware, sir, are that you have to record actions that need to be taken and that actions have been the actions that have been taken. I could argue that this is to do with actions that have been taken in relation to provision of general fire precautions, but such is the subjectivity of the legislation that there isn't a right or wrong, really.
Well, there is the concept of suitable and sufficient.
Yes. Yes, there is.
And the question is that where a fire risk assessor had not turned their minds to the question of whether or not previous recommendations had been satisfactorily addressed, would that render a fire risk assessment unsuitable or insufficient?
If they hadn't, well, a fire risk assessment is a snapshot of fire safety in the building at the point in time, a bit like an MOT. So, you know, if you take your car into a garage and they tell you what's wrong with it, and you bring it back on another time, and they tell you what's wrong with it, they've told you what's wrong with it, and they've given you a picture of the car as it is at that point in time.
Mr. Todd, I'm sorry to. That's not right, is it? They've told you twice, and the fact that they've told you twice is new and is different information from the fact that they've told you at all, isn't it?
they've told you what the car is like today, and a fire risk assessment tells you what the building is like today. I agree with you, sir. It's helpful, it's advisable. I would wish that to be in. But if I were to then be asked, well, where does legislation require that you do that, I would be struggling a little bit.
Well, let's just analyse this a little bit more closely.
Certainly, sir.
If previous recommendations had not been satisfactorily addressed,
Yes.
what might be the effect on the assessment of the risk?
The risk would be as the risk is. It would be the same as the risk would be the same as it was before, and that's what the risk assessor is reporting on.
Now, I want to understand that. Is there a difference to the fire risk assessor between the risk presented by an action unremediated,
Yes.
on the one hand, and the risk presented by an action which is unremediated and remains unremediated by the time of the second risk assessment? I would suggest to you that there is a different level of risk. Or do you disagree?
The level of risk is the same, but it reflects. I think we can agree on this. It reflects on whether the fire safety is being managed properly.
Yes.
If you find the same thing time and time again.
Yes.
And it's at that stage you would wish to escalate it. The risk, it will be the same on each occasion because the risk has gone on unremediated.
It's the unremediation that presents the new risk because it's a failure of fire safety management, isn't it? That's what I would suggest to you. And therefore, it's for that reason that it would have to be identified.
It would certainly be good practice to identify it. I think we could agree that, sir.
Well, I'm really seeking to explore with you whether it wouldn't just be good practice to identify it, but bad practice not to, unreasonable practice not to. And I suggest so because you are unreasonably ignoring the eventuation of a new risk.
Yes, I think that's something you'd wish to draw to people's attention, but I'm not sure. I mean, the risk to life will be the same, and it's a bad reflection on fire safety management that the risk is the same, but the risk is what the risk is, if you see what I mean, sir.
If a fire risk assessor had not considered whether previous recommendations had been satisfactorily addressed, and therefore not considered the effect of that failure on the risks presented by fire safety,
That would be wrong, sir.
That would be wrong. And the question then is, how could he adequately and competently assess the fire risk in the building concerned?
Because he would go through the whole thing again. If it was a review, then I would 100% agree with you. If it's a new risk assessment, then if the risk assessor is doing the job properly, he will find the same things as he found before. It would be a lot easier if he'd taken along the previous risk assessment and it would have made life easier for himself to check that things had been fixed. But if he looked at everything afresh, as it were, then he's going to find the same things as before.
It might be a function, mightn't it, of time as well. If you take your boxes in the basement,
Yes.
if the boxes are still there in a year or two's time,
Yes.
the boxes are still in the basement.
Yes.
No change in risk.
Yeah. Yes. The probability of them.
If you take your hotel with the fire alarm that is wearing out,
Yes.
in 12 months' time, it may be even
more worn out.
and therefore the risk
Yes.
is different.
Yeah, that could be true. Yes. Yeah, that would be true. But if you take my boxes, the probability of their ignition is the same as the probability of ignition last time. And the consequences, risk has two components, probability and consequences. Yeah. The probability and consequences for the boxes still being there is exactly the same as it was before.
Yeah.
Yes.
Even if there's a failure of management
Yes.
in not removing them.
But it's a bad reflection on management, sir.
It's a bad reflection on management, and therefore the fire risk of having a bad management system, which is one of the matters that you've set out in your report, has to be assessed.
Yes, it's slightly esoteric, but yes, I think we're not far apart, sir.
Very good. Now, looking at Carl's, let's look at a document, CST 403137. This is his letter of the 19th of October 2016. where he identifies some 23 actions outstanding from the previous fire risk assessment he'd done, which was, as we know, the 20th of June that year, 2016. Now, take it from me, we can scroll down, but all of the items were marked as high priority and therefore should have been completed, or at least started, to use Mr. Stokes's approach, within 2 to 3 weeks.
Yes.
And is that something that you would have expected Carl Stokes to have commented or advised on in this letter?
Sorry, tell me again about the context of the letter, sir.
The context of the letter was an invitation to Mr. Stokes to conduct an inspection of Grenfell Tower before an LFB audit.
Oh, I see. Yeah, so, okay.
And he did that. He went along, had a look,
In the hope
found
of heading off the problem.
outstanding actions, all of which were high risk.
Yes.
Now, my question is, would you expect him to have commented on the fact that those 23 items remained outstanding in this letter?
Yes, sir.
Yes. And particularly how those outstanding FRA actions then fed into the risk rating for the tower, which he had already assessed.
Yes.
Yes. And whether it showed shortcomings in the TMO's fire safety management.
Yes.
Yes. Now, in circumstances where a fire risk assessor becomes aware of a particular fire risk to premises outside the visit for a fire risk assessment, an ad hoc visit, such as this, for example, because perhaps he'd been told on a separate visit that someone is removing self-closing devices, would you expect the assessor to check any of the specific risks that had been addressed when undertaking the next FRA?
Sorry, ask that question again,
Yes.
sir?
Would you expect the assessor to check any of the specific risks that were thrown up by that particular visit when he comes next time?
Oh, I see. Yes.
You would?
Yes, I would.
So does it follow that if there are items that are outstanding, the fact that they are outstanding needs to be recorded in the new FRA?
Well, the fact of the deficiencies needs to be recorded in the FRA, sir.
But it's more than that. I'm suggesting that not just the deficiencies, but they remain outstanding, notwithstanding the fact that they were identified as deficiencies previously.
Yeah, I think, with respect, we're going back to the previous conversation.
It's the same again. Then let's move on to a different topic. Mr. Stokes' training, qualifications and experience. Now, let's go to your main report, please, first, Mr. Todd, page 54.
Yes.
And let's look together at paragraph 6.37 on that page.
Yes, sir.
And we see there you say, notably in his CV, Mr. Stokes states that he has experience in undertaking both audits, which I assume to mean on behalf of Oxfordshire Fire and Rescue Service, and risk assessments of the common parts of high-rise residential tower blocks under the fire safety order, and also fire assessments of the private flat-stroke dwellings, in quotes, under the Housing Act, presumably for the purpose of assisting the local authority which is responsible for enforcement of the Act.
Yes.
Now, if you go over the page to look, please, at paragraph 6.40, you say there, I make the assumption that, as stated in his first witness statement, Mr. Stokes' experience in Oxfordshire Fire and Rescue Service between January 1994 and September 2009 was, for the majority of his time, as a fire safety officer. On this basis, in my opinion, the period of experience, in conjunction with the activities described above, equates to substantial experience that would constitute more than sufficient experience for a transition into the field of fire risk assessment.
Yes, sir. Would you mind awfully if I went back to the previous paragraph?
Of course.
I'm sorry to take up your time, sir.
Not at all.
But
the bottom of page 54.
Yes, I feel bound in view of paragraph 637, and I'm sure the chairman will be aware of this, but just in case, watching Mr. Stokes' evidence, he appeared to contradict what he said in his CV, which I took at face value for 637.
Thank you. Fair enough.
I don't know if that's helpful, sir.
Well, it is what it is, and we will.
I just wondered if you were aware of that.
Let's see how we go, and if there's anything I'm missing, then you can elaborate. Let's put some of what Mr. Stokes. Let's look at what some of Mr. Stokes told us about his experience. And I will list them and then give the transcript references so people can check them. First, he said that the only fire risk assessments he undertook while at Oxfordshire Fire and Rescue Service were for fire stations. That's day 136, page 15, lines 9 to 15. He also said that otherwise he was in the role of auditing other people's fire risk assessments, day 136, page 15, 9 to 15 again. He never audited or conducted a fire risk assessment of a high-rise block of flats, day 136, page 16, 1 to 9. And by the time he retired from the Oxfordshire Fire and Rescue Service, he had had 3 years of fire safety experience as an auditor and less than 2 years' experience as a certified fire risk assessor, day 136, page 20, lines 1 to 7. Now, given that evidence, and I've summarised it, I hope accurately, but given that evidence, is it still your opinion, as you've set out in paragraph 640 of your main report that I've just shown you, that by the time Carl Stokes started his employment with Salvus in September 2009, his experience would equate to, quotes, substantial experience that would constitute more than sufficient experience for a transition into the field of fire risk assessment, as you say at paragraph 640?
Yes. Can you just run by me again what he claims is his auditing experience in under the fire safety order, sir?
He said he audited other people's fire risk assessments,
Yes.
But never audited or conducted a fire risk assessment of a high-rise block of flats.
Yes, but is his evidence consistent with the paragraph over the page that you took me to, sir, that he was actually a fire safety inspecting officer carrying out audits under the fire safety order?
Well, that's a question. I mean, I've put to you a summary of his evidence, and I'm just asking you, given that evidence, is it still your view, given what he told us, that he had substantial experience by September 2009 that would, in your words, constitute more than sufficient experience for a transition into the field of fire risk?
Yes, what I need to know to answer the question, sir, if you don't mind running through his evidence again, is how long was he auditing under the fire safety order? Does he now say?
Well, I'm not sure. I'm not sure I know the answer to that question, I'm afraid.
Right, but could you take me to 640 again, sir? I think it was 640 you took me to.
Well, I can tell you that he had. Yes, go back to page 640, page 55. I can tell you that, and we can go through his transcript if you like. I mean, that may take a little bit of time, and I'm trying to summarise it. But what he told us, in summary, is that he had 3 years of fire safety experience, and less than 2 years' experience as a certified fire risk assessor.
Yes, I watched his evidence and I thought there was possibly some misunderstanding of it. I think the 3 years he referred to was auditing under the fire safety order, right enough. But then in 2009, he couldn't have audited for more than 3 years under the fire safety order because it only came into force on the 1st of October 2006. And therefore, before that, as a fire safety officer, he would have been enforcing under the Fire Precautions Act. And that would, the combination would, in my view, be substantial experience in the application of fire safety, if that makes sense.
I see. Now, let's look at paragraph 539 of your report on page 47. This is about his continuing professional development.
Yes.
And, here you say, IFE policy is that registrants on their register of fire risk assessors must carry out at least 25 hours of CPD per annum, of which no more than half should be non-formal CPD. A log of the CPD must be kept and submitted to the IFE every 2 years. This is arguably a high standard yardstick for fire risk assessors, though in my experience, not one necessarily achieved by even all competent fire risk assessors.
Yes.
Is it your view that 25 hours of CPD a year is the standard that should be met by a fire risk assessor who is registered with the IFE?
That is what that's to say the IFE impose on registrants, yes.
Right. And would you expect a fire risk assessor who is not registered with the IFE to carry out the same amount of CPD each year?
Well, if he was not registered and applied for registration we would ask him to, or her, to up the level of their CPD, and that's frequently the case, that they haven't carried out enough CPD, and we would need to impose that requirement and give them a warning that that will be monitored in the future.
And what about fire risk assessors who don't register with the IFE? How much would you expect a non-registered person to carry out?
It will vary from almost zero to whatever figure you choose.
Right.
It will be down to their own integrity to determine for themselves how much they should do.
I see. I mean, for any years where let it be assumed as a fact that Mr. Stokes did not carry out 25 hours a year of CPD, would you agree that that fell below the standards of a reasonably competent fire risk assessor?
No, sir, I wouldn't.
Right. The IFE sets 25 hours
Yes.
a year. Is that presumably because that is what the IFE would expect from a reasonable...
It's quite a high bar to set, but it's a bar where we as the IFE, wearing my IFE hat, are quite serious about. But when people come along to register as competent fire risk assessors, we would see quite a number who are competent and that we are content to register, but that haven't been doing 25 hours.
Right.
And therefore, we need to draw it to their attention that, fine, they're registered now, but they will need to up the amount of CPD they do because they're not doing enough.
Would a reasonably competent fire risk assessor in the trade conduct no CPD a year?
No.
No.
A zero would be, that really wouldn't be acceptable.
Thank you. Now, if we go to paragraph 6.48 of your main report, at page 58, you say, page 58, you say at the bottom of the page there, it is clear that either Mr. Stokes is somewhat lacking in understanding regarding the proper use of post-nominals, or that he was at least endeavouring to overstate his qualifications. In either case, the manner in which he set out the supposed post-nominals would, in my opinion, significantly mislead clients and potential clients as to his qualifications, regardless of his level of competence.
Absolutely.
And is there anything that you heard from Mr. Stokes when he gave oral evidence to the inquiry that might change that opinion?
No, absolutely not. I recall, and you'll correct me if I'm wrong, sir, that he said he didn't know what post-nominals were. He had to look it up. And that's a matter for the chairman to decide as to whether that is correct or not. And moreover, I think you may hear evidence from others as to whether they reject his explanation or not. I think that's not a matter for expert opinion. That's a matter for the chairman to decide the motives. The bottom line is that there is no question in my mind that the post-nominals that he did set out after his name would definitely mislead people. In fact, and by evidence of that, if it might help, sir, after the Grenfell Tower fire, wearing again my IFE hat, I took calls from people who had looked him up. I think one of his risk assessments was on the web, and I had calls from people insisting that Mr. Stokes was on the IFE register and would not accept my word for it that wasn't correct, because you could not other than read what he'd written to mean that he was on the IFE register. The other post-nominals, anybody knowing post-nominals would possibly see through them, but there's no question that the package together would have misled people. I'm really quite clear about that, sir.
And when you say people, not just...
Clients.
Clients, but...
Clients and potential clients.
Anyone who read his reports?
Yes.
So residents of Grenfell Tower, the LFB?
Yes.
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 Yes. Now, in the light of that, can we go to paragraph 6.56 of your main report at page 62? And you say, at the bottom of page 62, in view of the circumstances outlined above, while I discount a number of the post-nominals used by Mr. Stokes in that they are not, in my opinion, relevant qualifications, I consider that Mr. Stokes' education, training and experience was suitable for the purpose of carrying out FRAs for Grenfell Tower and other buildings within the TMO-managed estate.
Yes.
Why was that, given the evidence that he gave us about his post-nominals?
About the post-nominals. Trying to think how to put this diplomatically.
You don't have to put it diplomatically. You just have to give us your opinion.
His evidence on post-nominals might mean that I might not want to buy a second-hand car from him, but he might be perfectly competent at fixing the car, if I could use that analogy.
Well, we'll do our best with it.
Can I elaborate at all?
Yes.
Well, we don't want too much beating about the bush. We need to understand exactly what your view is about this.
My impression is, and this is my impression, sir, that he tried to big himself up.
Yeah.
That would be my impression. He says he didn't understand and that he thought putting down courses that he'd been on in the form of post-nominals was fine, and that's all he was trying to do. My impression is he tried to big himself up. And the frustrating thing is, sir, he didn't need to. Right. Because he had the right experience, he had the proper training, he had, and I think this is worth bringing out, sir, the European diploma from the FPA. He used the wrong post-nominals for it. Again, frustratingly enough, but he did, and I had to check this for the Metropolitan Police, sir, and I did confirm that he had passed the European diploma of the FPA, which is a level 4 diploma, the equivalent of an HNC. So he actually had the academic training. As a fire safety officer for that length of period, anyone would be happy to employ him as a fire risk assessor, and yet he chose to, for whatever reason, have this string of post-nominals that would mislead people and big himself up, if I can use the vernacular, and there was really no need for him to do so.
Right. Thank you.
Thank you. Now, can we then turn to a different topic, which is audit, quality assurance, peer review? Can we go to page 28 in this document, your main report, and look at paragraph 4.17? You say there, however, it's important to note that in 2009 there were no third-party certification schemes for FRA companies. The TMA specification required that tenderers operated a quality management system, QMS, that conformed to BSEN ISO 9001, which in fact is a more onerous requirement in terms of management of quality than is required under the main third-party certification scheme that now exists for FRA companies. BAFE SP 205. Preference was expressed for the QMS to be certified by a United Kingdom Accreditation Service, UCAS, accredited third-party certification body. Accordingly, in my opinion, in 2009, the requirements of specification in terms of quality management were sufficient. Now, would you agree that it's important in general for a fire risk assessor's work to be audited and peer-reviewed?
There are lots of one-man companies who are unable to achieve that, sir, because there's no one, they don't have a partner or employee or anyone else working in their practice to do it. It's a known problem.
It's a known problem. Is that...
Or a known potential problem, to be fair.
All right, but the premise of the question I asked you was whether it was important for a fire risk assessor's work to be audited and peer-reviewed.
It depends on the competence of the fire risk assessor.
Well, with great respect, can that be right?
Yes, it can.
How would you? How objectively would you tell whether a particular fire risk assessor needed to be audited and peer-reviewed, and who would not?
A third party would have to make their own judgment, which is why we have third-party certification schemes. But you might be a perfectly competent lawyer, but you might not be registered on however lawyers are registered. So the risk assessor could be. I had a very good friend who would not pay for third-party certification. He took the view he was a perfectly competent fire risk assessor. He didn't need someone else to tell him that. was his view. His clients were asking for it. He was probably one of the best fire risk assessors I knew, but he just doggedly refused to submit himself to third-party certification. It didn't make him a worse fire risk assessor, but it meant that those using his services did not have independent verification of that. So it made it more difficult for them to assess him.
Now you say that it's a known problem for sole
Yes.
traders.
Yes.
And is the nature of the problem that there is no third party auditing or peer reviewing that fire risk assessors' work?
Yes, and on their day-to-day work, sir, under the BAFE SP 205 scheme, which is a company scheme, under that scheme, a one-man, one-woman company is a company for the purpose of that. So you can receive BAFE certification for your company as a sole trader with no one in your company to routinely audit your fire risk assessments. And so you will be limited to an annual audit by the certification body. Now, that has changed only recently because there are many of us in the profession that consider that, I think what you're implying, that if you're a one-person company, how do you yourself know that you haven't gone off in some funny tangent and you've got no one to bring you back in line by routinely auditing and checking or peer reviewing your fire risk assessments. Now, the Fire Industry Association have made representations to BAFE about that, and BAFE now call for a slightly higher level of monitoring of one-man companies, whereby they have to submit another fire risk assessment in the interim period for review by the certification body. But there is concern by many of us that on a day-to-day basis, if you are a one-person company, you might be very competent, but you are devoid of peer review to confirm that, and as it were, to keep you on the straight and narrow.
Yes. Now let's look at page 36 of your report at paragraph 4.45. You deal here with the absence of peer review.
Yes.
And you say in the second half of that paragraph, the only possible disadvantage would be that associated with employment of any sole trader, namely the absence of any internal peer reviews of FRAs prior to submission.
Yes.
Plus the more minor potential for delay in the programme as a result of sickness, etc.
Yes.
You refer to internal peer reviews, but what about the absence of any audit procedure or quality assurance procedure? Did you consider those factors when you wrote this paragraph?
Well, the peer review is all part of quality management. It's the peer review that's missing from sole traders, but I would not wish to speak badly of sole traders. I've got a number of friends who are sole traders carrying out fire risk assessments who do a very good job, but no one is actually reading and peer reviewing their reports. And to my mind, that's a disadvantage, but that's their choice.
Yes, you use the word disadvantage here, but
yes.
Given that Mr. Stokes became the TMO's essentially permanent standing and only fire risk assessor for the entirety of their stock of some 650 buildings, would you agree that the absence of a QMS, a quality management system, in place for him was more than just a disadvantage? It was a serious problem.
We need to pause there, sir. A one-man company can have a QMS. There are one-man companies who are third-party certificated under BSEN ISO 9001. I've actually audited some on behalf of UCAS. Well, I've audited the certification body auditing the one-man company on behalf of UCAS, and they can run a QMS that's perfectly adequate under 9001.
Indeed.
The bit that's missing is the bit on top, if you like, to have a friend, a critical friend, to look at their fire risk assessments.
Well, Carl Stokes told us that he had no auditing procedure and no quality assurance system in place while he was working for the TMO, contrary, in fact, to what had been specified by the consultant's brief. In the light of that, and given the scale of his task, as I've identified, would you agree that the absence of any quality management system in place, and indeed any audit or peer review, was more than just a disadvantage to the TMO? It was a serious and fundamental problem.
No, I would stick with disadvantage, sir.
Are you able to tell us where, on a scale of seriousness, disadvantage might lie?
And again, sorry, I don't know what the inquiry already knows. Have quality management systems been explored and explained to the inquiry?
Well, I don't think we've had an encomium from somebody about it.
Well, can I give you the key points?
Well, I think it needs to be brief, if you can, Mr.
I'll do my very best, sir. So if you have an ISO 9000 quality management system, you have to have a controlled document list. You have to have a methodology which is audited to keep all your British standards up to date. But people may do that on an ad hoc basis. You have to have a customer complaints system. If you're a one-man company, you probably know what your complaints are. You have to have a policy of continuous improvement. If you're a committed one-man company, you can have a policy of continuous improvement. So you can meet all the components of ISO 9001 as a one-man company. I'm not saying Mr. Stokes did. I'm just saying you can. And the bit that is missing on top of the ISO 9001 is the peer review of your product. And that's a disadvantage, but it's one that is inherent if you employ the services of a one-man company. But there are lots of perfectly legitimate one-man companies who work for reasonably sizable organisations.
Can I just ask, Mr. Todd, you currently stick by the word disadvantage.
Yes.
As opposed to Mr.
Serious.
It's rather more.
Yes.
Serious language.
Yes.
The word passing through my mind was that it was a weakness.
A weakness, yes.
Would you accept that?
Yes, definitely, sir.
Yeah.
And let's turn to a different topic, namely Mr. Stokes' FRAs, and start with some general points. And of those general points, I want to ask you about cutting and pasting, if I may.
Yes.
If we go to page 75 in your main report, and look, please, at paragraph 8.9, you can see that there is a set of bullet points under that paragraph.
Yes.
And you're focusing there on the June 2016 FRA for Grenfell Tower in particular.
Yes.
And you say, there is evidence that Mr. Stokes was quite meticulous in the detail he recorded, though I have slight concerns that some of the content was standard wording, which he incorporated in all of his FRAs as something of a cut and paste. For example, for some reason, the June 2016 FRA for Grenfell Tower contains a section on pest control in which it is recorded that pigeon netting had been erected to cover the flat balconies, which Mr. Stokes states were inspected visually from the ground, when in fact there are no flat balconies. Now, you use pigeon netting there as an example. Would you seriously describe as meticulous the work of a fire risk assessor who cut text from an FRA for building A and pasted that into an FRA for building B, where it was completely inapposite?
He went into incredible detail, but you would then have to sort out which of that detail was something of a cut and paste, and which was specific and unique to the building. Now, there was a lot of information recorded that was unique to the building. It was undermined and diluted by the fact that he cut and pasted things like pigeon netting. And going back to our previous point, and the chairman's term weakness, if it had been a two-person company and every report had been read by a colleague of Mr. Stokes, the colleague probably would have said, "Are you sure you've got pigeon netting at Grenfell Tower?" So that's the sort of problem you can have by having someone who is a one-man company and is perhaps a bit careless in reviewing their own report. But on the other hand, quite a lot of the detail he did record was unique to Grenfell Tower, which was a telltale sign that he had carried out a thorough inspection of the building and then jotted down quite a lot of detail.
Well, you just, in that last answer, within it is the seed of my next question. You say perhaps a bit careless in reviewing their own report.
Yes.
Do you agree that that a cut and paste approach, as you've exemplified with your pigeon netting example, is in fact very far from meticulous because it shows that the author did not bother to read their own work before signing it off and sending it to the client?
He certainly can't have read it properly.
No, that's not very meticulous, is it? Never mind the detail.
Well, I don't want to get into semantics. He did record down, he did jot down a lot of detail of what he'd seen, but he clearly didn't read the report properly thereafter, or he would have seen that something like pigeon netting wasn't appropriate. And there were other examples as well. That wasn't the only one, sir.
You see, you say in the second line of the first bullet point there that you have slight concerns with
Yes.
some of the content with standard wording incorporated in all his FRAs. Why did the fact that Mr. Stokes recorded the presence of pigeon netting over balconies for Grenfell Tower when there were no balconies and no pigeon netting, something that only gave you slight concerns?
It gave me concerns because it made it difficult to resolve which of the information was specifically relevant to Grenfell Tower and therefore was accurate and which was not. But in relation to quite a lot of the detail, it was clear that it was unique to Grenfell Tower, like rust on an escape hatch. I mean, that shows quite an eye for detail. And therefore, and he recorded that detail, but it meant his report was a little bit of a mess because of the fact it was to the detriment of the report that there were things that were clearly not right and were cut and paste.
Yes, it's just a question of why you say slight concern.
Why a slight concern?
Yeah.
Because putting that down didn't put anyone at risk.
No, but doesn't it show that Mr. Stokes failed to read his fire risk assessment properly before sending it to the client?
Yes, it does.
And that is, why is that something that only gives you slight concern? It's not a serious problem, isn't it? You don't read your own work before signing it off.
I think it's very bad practice.
Well, you wouldn't have done it with your expert's report, would you?
No, sir.
No.
I had 3 people peer
I
review.
just wonder whether you've understated it a little bit here.
Perhaps I would be happy to delete the word slight if you wish, sir.
Let's turn to evacuation strategy.
Yes.
More substantively. Now, let's start, as it were, at the beginning. Can we look at the FSO? INQ 30s 11327 at page 10. This is Article 14, Emergency Routes and Exits.
Yes.
And under Article 14.2, it says quite a lot, but it provides a set of requirements with which the responsible person must comply.
Yes.
In order to safeguard the safety of relevant persons, doesn't it?
Yes, that's
relevant
correct.
persons is a defined expression.
Yes. It is.
B, in the event of danger, it must be possible for persons to evacuate the premises as quickly and as safely as possible.
Yes.
Yes. Now, was it the understanding in the fire risk assessment trade before Grenfell Tower, before the fire, that in the event of danger, the responsible person was required to ensure that persons could evacuate the relevant premises as quickly and safely as possible without the assistance of the fire and rescue service?
In anything other than a block of flats, that would be true, sir, yes.
Is there any qualification so far as concerns blocks of flats to this obligation in the FSO?
Inherently, sir, because with the greatest of respect, you didn't read the whole of the sentence, which is a very common problem because of the way, the very unhelpful way the articles of the fire safety order are written. So, for example, by analogy, sir,
yes.
If you were to look at 14.2d, you would read that emergency doors must open in the direction of escape. Always. Absolute. But that's not correct.
In what way is it not correct?
Because in many buildings, the doors open inwards, and that's perfectly acceptable, and guidance says so. And so the question is, where do I get that from? And I get it from, sir, two very important words: where necessary. And in fact, when we train people on this very article...
Just pause, please. The words "where necessary" that you're identifying for us...
First line
here at the end of the first line in
That's correct.
Regulation 2.
Yes, and they're very, very important.
I see.
So important are they, sir, that they actually delayed the introduction of the fire safety order from April 2006 till October 2006. I would put it as strongly as that.
So are there cases where, looking at B, it is not necessary in the event of danger for it to be possible for persons to evacuate the premises as quickly and as safely as possible?
Well, if you have a stay put strategy, then you still have to have adequate means of escape. But in the event of danger, you don't actually have an evacuation strategy as such. You have a stay put strategy.
But a stay put strategy is not exceptionless, is it, as we know?
No.
And hence the words "must be possible." Now, I don't want to get into a debate about the meaning of a regulation. What I'm keen to understand, coming back to my question,
Yes.
is whether it was the understanding in the fire risk assessment trade that in the event of danger, the responsible person had to ensure that persons could evacuate the relevant premises as quickly and as safely as possible.
Yeah, you can encapsulate that.
Sorry, the qualification is important. Without the assistance of the Fire and Rescue Service. That's the question.
I see. Then there will the understanding in the trade, as you put it, sir, is that in a building with a stay put strategy, then there had to be adequate means of escape still, for the reasons that you explained.
Yeah.
But the understanding was, and this may be where you're leading, sir, if persons couldn't because of disability, then they would be rescued by the Fire and Rescue Service.
Yes. That I understand. Was it the understanding in the trade also that this obligation here, read in full, applied regardless of whether the responsible person had a stay-put strategy for those premises?
Yes, because you'd have to provide adequate means of escape.
Yes.
Staircases and the likes.
So even where, so we're clear, even where a stay-put strategy was in place, was it the view at the time that any resident of that building affected by fire and or smoke should also be able to evacuate the premises as quickly and as safely as possible?
It was an understanding that was reflected in the LGA guide that in the case of persons with disability, they would need to rely on rescue by the Fire and Rescue Service.
We'll come back to persons
achieve
with
that.
disability in detail later on in your evidence.
Yes, sir.
But just in general terms.
In general terms, yes, sir.
Yes, you agree, yes.
Yeah.
And that safe evacuation should not depend on the intervention of a Fire and Rescue Service.
Other than for disabled people in blocks of flats.
Thank you, right. And do you agree that it's the responsibility of the premises management to assess the needs of all people to make a safe evacuation when formulating evacuation plans?
Yes, as far as practicable.
And an evacuation plan should not rely on the assistance of the Fire and Rescue Service, which, and that's a matter actually which should be taken into account in building design.
I come back to the fact that the understanding at the time was that in the case of persons with disability, there would need to be reliance on the Fire and Rescue Service.
Now, on that point, just go back to Article 14.
Yes.
Again, I hesitate to debate the language used by the order, but
yes.
Do you agree with me that nowhere on its face does it distinguish between able-bodied and vulnerable persons?
No. Yeah, that's correct.
Was it the understanding in the trade that Article 14 did, perhaps implicitly, did make that distinction, or was it the understanding that it didn't and wasn't supposed to?
The understanding was that In a building with a stay-put strategy, it would not normally be necessary. However, as you pointed out, sir, even in a building with a stay-put strategy, there will be a need sometimes for persons to evacuate. That evacuation, because there's no fire alarm system, would normally be triggered by the fire and rescue service.
So, in your view, did those in the fire risk assessment trade think, before the Grenfell Tower fire in June 2017, that where a disabled resident or vulnerable resident was affected by smoke and or fire, the responsible person had an obligation to ensure that that resident could evacuate the building as quickly and as safely as possible?
The understanding would have been that this related to the safety of persons within their dwellings, which was outside the scope of the fire safety order, but you could not simply ignore the safety of disabled persons. No. Because the most likely scenario, and I think the chairman asked this question of a witness, and it was an incredibly important question: what if the resident has a fire in their own flat? And I'm not sure that the chairman ever got an answer to that. He may have done. But the point is that the safety of disabled people in their own flats, it, paradoxically enough, is not adequately addressed by an evacuation plan. You need more than that. And in fact, nowadays, we would say that a PEEP, to use that term, and I know you haven't introduced it yet, sir, is only part of the means for securing the safety of disabled people in their own flat. Because if they die from a fire, it will almost certainly be a fire in their own flat. Grenfell Tower is a dreadful, dreadful, obscene anomaly. And since the Grenfell Tower fire, sir, 180 people have died from fires in purpose-built blocks of flats. And almost without exception, perhaps without exception, these are people who died from a fire in their own flat, often vulnerable people, very often older people, vulnerable through simply age, people with disabilities. And arranging for their evacuation when there's a fire elsewhere in the building is negligible compared to ensuring that they are safe from a fire in their own flat. And traditionally, sir, before Grenfell Tower, we recognised this. We didn't ignore disabled people, far from it. But it was deemed to be a matter not for legislation, which was deemed to be a very blunt instrument with which to try and deal with the problem, but by multi-agency working to identify these people and ensure that with multi-agency cooperation, measures could be taken to ensure that they didn't die from a fire in their own flat, which was the most likely scenario to occur. And that would be true, sir, if you had a bungalow in the middle of a field. If you have a bungalow in the middle of a field with a person who is bedridden, the fire safety order doesn't apply. You can't have a PEEP. No one's going to go and rescue them other than the fire service. But you don't simply write them off. Far from it. You provide a package of fire safety measures to make sure, A, that they're unlikely to have a fire, and B, that if they do have a fire, they are safe until the rescue by the fire and rescue service. And that's much, much broader than a PEEP. And today, we call that a person-centred fire risk assessment, or PCFRA. And you'll find reference to that in guidance that I drafted, sir, and people can characterise me as the author of that if they wish. 2017, Fire Safety and Specialised Housing. And that's written around sheltered housing, supported housing and the likes. And we introduced the concept of the PCFRA. We didn't invent it, but we introduced it into national guidance before Grenfell, but in the same year as Grenfell. And perhaps tucked away in that, and perhaps not prominent enough, but we actually do say this is for specialised housing, but if you have a disabled person in general needs housing, you can do the same thing. and create, we often refer to it as an island of sheltered housing in general needs housing. Does that make sense, Chairman?
Yes, thank you very much.
Yes, Mr. Todd, it's a rather long answer. I'm seeking to understand...
I'm sorry, I'm doing my best to keep it short.
Well,
Can I just, sorry, I'm going to intervene for a moment because I think from time to time, in your enthusiasm to ask the questions, Mr. Millett, and in Mr. Todd's enthusiasm to answer them, you're sometimes cutting across each other at the end.
Sorry, sir.
No, it's right. It just makes life very difficult for the shorthand.
Yes, I understand.
Yes, Mr.
yes.
Sorry. Go.
I just want to try and understand what the trade understood by Article 14, and particularly Article 14.2b.
Yes.
Was it, coming back to the question, was it understood by the fire risk assessment trade that reliance on the existence of stay put in a residential high-rise building was not a sound reason for not discharging the obligation under little b there, or that it was an acceptable way of discharging it, or didn't need to be discharged?
There was a general understanding that stay put would work, and in general it did.
So, does that tell us that people thought that stay put meant that you didn't have to think about evacuating disabled people?
There would be some would take a different view from what I'm about to say, sir, but I would say the majority view was exactly that. But if it came to a stage where you needed to evacuate people beyond the flat of fire origin, it was understood that given that there was no fire alarm, how would this disabled person know that there was a fire elsewhere in the building and there was a need for them to evacuate? That would be because the fire service had come to their door and told them so. And at that stage, both practically and legally, under the Fire and Rescue Services Act 2004, the fire service are legally in charge of the building. And the fire service, it was understood, would arrange for their evacuation. Now, whether the inquiry consider that was appropriate or not appropriate, that was, I would say, the majority understanding in the profession, albeit not possibly 100%.
Thank you. Now, can we look at the next article, Article 15, at the foot of the page?
Yes.
Procedures for serious and imminent danger and for danger areas.
Yes.
And it says the responsible person must establish and when necessary, give effect to appropriate procedures, including safety drills, to be followed in the event of serious and imminent danger to relevant persons.
Yes.
And then secondly, under B, nominate a sufficient number of competent persons to implement those procedures insofar as they relate to the evacuation of relevant persons from the premises. And then over the page at little c, ensure that no relevant person has access to any area to which it is necessary to restrict access on the grounds of safety unless the person concerned has received adequate safety instruction.
Yes, sir.
Was it your view, or rather was it the view in the trade, that the responsible person was required to establish an appropriate procedure to be followed in the event of serious and imminent danger to relevant persons?
Yes, and that would translate into, I think you may be aware, sir, that what you're reading here is the actual wording of the Workplace Directive from Europe on health and safety. So it's not terribly clear language when translated into English. This is not written around fire safety. This is verbatim reproduction of the Workplace Directive or the Framework Directive on health and safety in workplaces.
How much of Articles 8 to 22 was taken from the Workplace Directive?
Well, the whole of 14 would be the Workplace Directive. 13 would be. You need to do a comparison, but a lot of the key, the 15, 18 would be, 16 would come from the Explosive Atmospheres Directive because it's to do with flammable substances. Quite a lot of the key physical measures that are called for under the Fire Safety Order were copied out from the Fire Precautions Workplace Regulations or more broadly what was known as the Workplace Fire Precautions legislation, which was copied out, and that was the government's actual term. This was not a loose term. The government, in preparing the previous generation of legislation to this, said that they were going to adopt a principle known as copying out, where they copied out the wording of the directives. And to prepare the fire safety order, they copied it out yet again, but expanded the scope to relevant persons instead of just employees. Now, I'm sorry if that was a long answer to your question, and I'm going to come to the answer to 15. So the understanding, again, I would say the majority, but not the 100% consensus, would be that in a block of flats, the Article 15 duty was satisfied by having a stay-put strategy. People actually call that an evacuation strategy, which is a misnomer because it's a non-evacuation strategy.
Well, quite so. And that's the question I was going to ask you. So your opinion or your evidence is that the responsible person, as a matter of practice, and fire risk assessors, as a matter of practice, would regard the obligation under 15(1)A as satisfied simply by the presence of a stay-put strategy in a high-rise.
Yes, with the caveats included in a stay-put strategy.
Indeed.
So in lots
Indeed.
of people's risk assessments, and I get to see hundreds of risk assessments of others apart from our own practice, you will often find heading evacuation strategy, and underneath that, the risk assessor will commonly write stay put.
Yes. So does that tell us that in a high-rise residential building, in respect of which a stay-put policy or strategy is in place, there would be no emergency plan, or rather that would be the emergency plan?
No, the emergency plan would go a little bit further, that if you wish to evacuate and can do so, you're entitled to do so. The stay put does not keep people prisoner. Or if your flat is affected by fire and smoke, then you should leave, or if you're instructed to leave by the Fire and Rescue Service. That's the sort of standard wording of a fire procedure notice, and that in its that holistically would be what people understood to be compliance with Article 15.
I see. Now, can we look at the LGA guide on this?
Yes.
HOM 3045964, please, at page 27, section 18.
Mr. Millett, forgive me, I'm sorry, I keep interrupting. Transcriber, how are you doing? We're going to have another 40 minutes till lunchtime. Is that going to be all right? Well, will you flag if it's not, please? Thank you. Yes, Mr. Millett.
Yes, Mr. Chairman, certainly. This is entitled Evacuation Strategy.
Yes.
It's 4 subsections long. If you look at paragraphs 18.1 and 18.2,
Yes.
They explain the principles of compartmentation.
Yes, sir.
And then if we look at 18.3, it says this is the essence of the stay-put principle. It has underpinned fire safety design standards from even before the 1960s, when national standards were first drafted. It's still the basis upon which blocks of flats are designed today. In the majority of existing blocks, it remains entirely valid. Inevitably, fires do occur, in which, for operational reasons, the Fire and Rescue Service decides to evacuate others in the building. Fires have been known to spread beyond the flat of origin to involve other flats or to spread across the top of blocks through the roof voids. In these cases, total evacuation of the block has sometimes been necessary. Fortunately, these fires are rare. They are usually the fault of failings in the construction.
Yes.
Now, it looks from this LGA guide that it contemplated the possibility of compartmentation failing.
Yes, sir, that's correct.
Even if it was rare, yes. Do you agree that if compartmentation were to fail, or taking your word from yesterday, bypassed, that would present a serious and imminent danger to relevant persons in the building?
It could do, yes.
Yes. Do you agree also that the responsible person should ensure that a resident can evacuate as quickly and as safely as possible in the event that compartmentation either failed or was bypassed?
Yes, and that's why we have protected stairways, protected lobbies, smoke control, and so on.
Yeah. And do you also agree that the responsible person was required to establish and give effect to a procedure to be followed in that eventuality, even if rare.
Yes, and that's why the standard fire procedure notice would say what I said it would say.
Yeah. And does that tell us that the responsible person was obliged to assess the means of escape, both when the stay put strategy is in force and when it was revoked because, for example, compartmentation had failed or was bypassed?
Yes, it goes to the same thing, the fire procedure.
Yes. So it was not your understanding that the responsible person was not required to put, and forgive the double negative, it wasn't your understanding or the understanding of the trade that the responsible person wasn't required to put in place any evacuation arrangement in the event that compartmentation failed or was bypassed, but would simply leave it up to the fire and rescue service to do whatever it needed to do by way of evacuation.
No, because they would need protected stairways by which residents could evacuate, or the fire and rescue service could evacuate people who could not evacuate themselves. That's why we regard the staircase as sacrosanct.
Yes, thank you. Now, let's turn to the FRA responsible fire risk assessment responsibilities to assess the means of escape. And we can start with PAS 79, please, on that topic at page 44. CTA 703, page 44. This is under the title Means of Escape. And if you look at Little Roman 23, and this is, I should just tell you, part of the commentary under paragraph 15, which starts on page 41. We don't need to go back to that.
Yes.
But the title to this section is Assessment of Fire Protection Measures. You'll be familiar with that.
Yes.
And it says here at Little Roman 23, under the heading Means of Escape, in considering the likely consequences of fire, the fire risk assessor needs to consider the likely effects of fire on escape routes, C320, during the escape time, C321, taking into account the time for detection of fire and raising the alarm, see commentary on clause 15, fire detection and warning. This requires a thorough evaluation of means of escape.
Yes.
So is it the case that the fire risk assessment would need to include an assessment of the means of escape in a high-rise residential block?
Absolutely.
Yes. And then if we look across to the right-hand side of the page to Little Roman 27, you can see that this PAS sets out 5 critical factors in the assessment of means of escape, which are listed under little a to D. Can you see?
Yes.
And if you look down at E, well, D is also, I think, important, but the D says the means of protecting escape routes from ingress or build-up of smoke that prevent occupants' escape. E, the ability of occupants to use the escape routes.
Yes.
Do you agree that the fire risk assessor should, indeed must, take into account these critical factors when assessing the means of escape?
Yes, so that's correct.
Yeah, and that would include critical factor E, the ability of occupants to use the escape routes.
Yes.
Yeah. And that would that include all occupants, including those who, by reason of vulnerability of some kind, might be unable or be less able to use the escape routes?
Yes, and particularly in non-domestic premises, one would go to quite a length to look at that.
Yes. Then if we look at the next paragraph, 28, it says, it can normally be anticipated that occupants with disabilities are or are likely to be present on the premises.
Yes.
And consideration needs to be given to arrangements for their evacuation in the event of fire. In most multi-storey premises, designated refuges are likely to be necessary as temporary waiting spaces, and there will be a need for arrangements to assist mobility-impaired occupants to escape from the refuges using staircases and/or specially designated evacuation lifts, or firefighting lifts which can be used to evacuate disabled people by people in the premises at least until arrival of the fire and rescue service.
Yes.
Now, PAS 79 recommends that the fire risk assessor assesses the arrangements for evacuation of occupants with a disability.
Yes.
You agree with that?
Yes.
Do you also agree that the fire risk assessor should also take these factors into account when carrying out a fire risk assessment of a high-rise residential block?
Yes, but possibly more generically.
What do you mean by that?
What I mean by that. So if I were, or any fire risk assessor were looking at an office building you would sit down with the management and say, do you have any disabled people? And that includes all disabilities, not just mobility impaired, deaf people, blind people, whatever. And inevitably, you will find one or two. And the emphasis here on not relying on the Fire and Rescue Service was really aimed at non-domestic premises, and I need to explain the reason for that. There was a really horrifying understanding by some people, some responsible persons, and this would be up to large corporate bodies. Their understanding was that disabled evacuation was all about physical measures, not management measures. So they were perfectly willing, and with their heart probably in the right place, to create refuges, put communication systems in the refuges, and then think, job done, the fire service will get them out now. And that was an extremely common and highly inappropriate misconception. And it was important to get across to people in non-domestic premises that evacuation of their disabled people as employees and members of the public who come on their premises must not rely on the Fire and Rescue Service. There had to be designated employees who would act as, common term, as buddies, and who would, as part of a disabled evacuation strategy, evacuate disabled people in the event of fire. And so that's why there was this emphasis on not involving the Fire and Rescue Service. And as I explained yesterday, sir, PAS 79 2012 was really focusing on non-domestic premises, notwithstanding, you're quite correct to point out the footnote. And so our focus was to dispel the misconception that you can just leave disabled people in refuges. And people were doing it. It wasn't just hypothetical. People were being left in office buildings, disabled people were being left in refuges while all their colleagues left. And we needed really, quite urgently, to dispel that myth.
Why not dispel it also in respect of residential high-rise buildings?
Because there are no staff to evacuate disabled people. There are no trained staff. And therefore, you have no one to implement what's described here for non-domestic premises.
Right. Well, given, as we established yesterday, that it is not in doubt that this PAS applied to high-rise residential blocks, is there anything in it which says that you can take a different approach in respect of these 5 critical factors, and particularly E, as between an office block on the one hand and a high-rise residential block?
No, I don't actually think there is. And as I said to you, that is why, after Grenfell Tower, the housing sector wanted something that was more specific to housing, because this was really written around commercial premises.
But you're telling us, you see, about the practice in the trade. Do I
Yes.
take it from your answer that the practice in the trade was essentially a 2-tier one, that you would apply 28 or 27E root and branch to office blocks or factories, for example, but when it came to high-rise buildings, not so much?
I wouldn't call it 2-tier, I would call it different.
Well, all right. It's one difference,
Yes.
2 tiers.
Yes.
I mean, that's a quibble. I mean, what I'm really putting to you is that is it right that the fire risk assessment trade regarded it as appropriate to take a different approach to disabled people in high-rise residential buildings from the approach they would take in an office block?
That would have been the majority opinion, sir, yes, although people will, with the benefit of the lens of hindsight, argue about that now, but that would have been, I would have said, we trusted in stay put, basically.
And is there anything in the majority opinion, is there anything in the legislation or the guidance which would justify that majority opinion?
I'm not sure that I can point to anything. It's a matter of reasonable practicability, sir. I mean, if we go back to 28 for one moment, and we look at this, designated refuges Well, I've never seen a block of flats with a designated refuge, sir. By definition, the common parts are performing the purpose, the function of a refuge. But I've never seen a block of flats with a designated refuge in my life. I've never seen a block of flats with an evacuation lift. There'll be firefighting lifts for the fire service, but I've never seen a block of flats with an evacuation lift, although the Mayor of London is doing something about that, apparently.
Now, you say it's a matter of reasonable practicability.
Yes.
Going back to the long answer you gave earlier about a fire risk assessor sitting down with the management and saying, do you have any disabled people?
Yes.
That includes all disabilities, etc.
Yes.
What was not reasonably practicable for a building owner or building manager of a high-rise residential building to sit with the fire risk assessor and tell the fire risk assessor exactly the same information?
Could we scroll down a little bit, sir, so that we can see the whole picture? So if we go on to 29, assistance with their evacuation is provided by persons within the premises. What persons in a block of flats would that be? A two-way speech communication system within the refuge might be necessary. This is so that the disabled person in an office building can talk to someone at reception, tell them that they need to be assisted with evacuation, and also receive reassurance. That's why we ask for it to be two-way. My company actually invented the systems that are used for that purpose, and we penned a name for them: emergency voice communication systems, and that was to help disabled people in commercial premises. You do not get EVCS in blocks of flats. It is, I would say, completely unknown unless someone can find.
So come back to the question I asked you.
Yes.
Why was it not reasonably practicable for a building owner or building manager to collect the same information about disabled people in their high-rise residential block as it would for a high-rise office block?
Because in a high-rise office block, the purpose of collecting the information is to make sure that there are designated employees who, in relation to the particular disability of the person, are able to provide them with assistance to evacuate.
Right.
In a block of flats, you don't have such people.
Right. What I'm taking from this exchange we've been having over the last 5 minutes or so is that these parts of means of escape under Clause 15 of this PAS were really inapposite for a high-rise residential block of flats, at least so far as the ability of occupants to use the escape routes is concerned. Or is that not right?
I think it was an interpretation of Article 15 that we come back to the fact that the evacuation strategy, much as it might be a misnomer, was a stay-put strategy. And I think if you were to scroll through this, you might see other telltale signs that this could not really be talking about a high-rise block of flats.
But the problem with that answer, Mr. Todd, is, as I think you accepted yesterday, and according to footnote 1, the entirety of PAS 79 applies to high-rise blocks of flats. But do I take it from the answers you've been giving that although that's written, it wasn't actually intended to be that way, and in practice not understood that way?
There would be certain aspects that would apply to a high-rise block of flats. So, for example, fire prevention, keeping escape routes clear, not having combustibles in escape routes. All of these things would be applicable to a high-rise block of flats just as much as to any other building. So there, unfortunately, it would be a bit of a curate's egg. There would be bits of PAS 79 that would be entirely applicable to a high-rise block of flats, and there would be bits such as that on which you've honed in that would clearly not really apply to a block of flats.
How would your average fire risk assessor know which bits to apply and which bits not to apply when going along to fire risk assessor building like Grenfell Tower?
Because they had the appropriate education, training and experience to apply the principles of fire safety.
When you were lecturing and giving these courses to people, did you ever pick up PAS 79 and say, well, don't worry about Clause 15, subclause 27, 28 and 29, because they don't apply to residential high-rises, do worry about them and do apply them when it comes to office blocks.
No, we didn't put it that way. We would put it that Article 15, in the case of a block of flats, generally will be satisfied by the stay-put strategy and the wording adopted in a stay-put adopted in a stay-put strategy.
Well, coming back to 29, which you referred to,
Yes.
I had some questions of my own about it. Does it not signal to the responsible person and the fire risk assessor advising the responsible person that they could not just leave it to the fire brigade to assist disabled persons to evacuate? The responsible person needed to have a system in place of its own, regardless of whether it was an office block or a high-rise residential block.
I think we were gradually coming round to the view that information about disabled people in a premises information box might be appropriate, but I would call that gradual. That would be completely accepted in sheltered housing, where you're expecting the majority of the residents to have some form of limitation in terms of mobility, hearing, or whatever. And so information about disabled people in premises information boxes had become kind of standard for sheltered housing. It hadn't become standard for general needs.
Well, we'll come to that, because I think you cover it in I think it's 79.3 of the LGO guide.
Yes.
You'll know more than me, but we'll come back to that in due course. Just on this, though, Mr. Todd, does 28, 29, and indeed 27 E, 28 and 29, not signal to the responsible person that they had to have a system in place, at least a system in place, for the evacuation of disabled persons, all persons, regardless of disability?
The understanding would have been that that system would be that the fire service, because I keep coming back to the fact, sir, that the disabled person, their evacuation is not triggered by any form of alarm system. Their evacuation would normally be triggered by the fire and rescue service, and if they needed assistance, the fire and rescue service, who had control of the building, would arrange that.
Right. Now let's explore that. I think you've said that a number of times.
Yes, I have, sir.
To be honest, and perhaps
I'm sorry to repeat myself.
No, it's me, I think, inviting you to repeat yourself, but never mind. Let's look at your report. Can we go to page 121, please, and look at section 12? This is your Phase 1 report, not your main report for Phase 2. This is your Phase 1 report.
Yes.
At CTR 701.
Yes.
I'm sorry, I've given, this is my fault. I'm afraid I've given you the wrong reference. CTAR 701, page 121, thank you. And this is section 12 of your Phase 1 report. And at 12.7 at the foot of the page, you say, furthermore, in a general needs block of flats, it is not practicable to nominate persons to implement fire procedures insofar as they relate to the evacuation of a resident when a fire occurs in their flat. In effect, this would entail the provision of a sufficient number of suitably equipped staff within the building on a 24-hour basis to force entry into a flat and effect a rescue. And then if we look at page 123, please, next page, at paragraph 12.19, you say there, in a block of flats with a stay-put policy, it has always been recognised that a decision might be taken by the Fire and Rescue Service to evacuate residents beyond the flat of fire origin. As discussed in paragraph 9.2.35, in over 99% of fires in blocks of flats in 2009 to 2010, no more than 5 persons were evacuated with the assistance of the Fire and Rescue Service.
Yes.
And then at 12.21, a little lower down the same page, if we could just scroll up so we see the whole thing. Thank you. When such further evacuation of residents is necessary, or when residents simply choose to leave their flat during a fire elsewhere in the building, by virtue of compliance with Article 14 of the Fire Safety Order, there will be suitably protected means of escape, which would have been required under building regulations for them to do so. No special facilities are provided specifically for residents who cannot walk down a staircase. The maintenance of the means of escape is addressed by Article 17, while consideration of their adequacy is necessary in the fire risk assessment required by Article 9.
Yes.
And then, I'm sorry to read a lot to you here, but last one, 1222, foot of the page. It is sometimes necessary that this reliance on the fire and rescue service is contrary to the principle in fire safety whereby occupants of buildings should be safe in the event of fire without fire and rescue service intervention. Basically, buildings should stand alone without the involvement of the fire and rescue service in evacuation. It is correct to say that service is not a fire and evacuation service, nor would it be acceptable for them to be regarded as such in a building with a simultaneous or phased evacuation strategy. Now, I've read a lot of that to you. I have just a number of questions, but is it your position, first, that the FSO does not require any special consideration of vulnerable persons?
No.
You agree that it doesn't, or is it your position that it does?
The FSO applies to everybody.
It applies to everybody, yes. And is it because the compartment, so far as vulnerable persons are concerned, compartmentation underpins the stay-put strategy?
Correct.
And if the stay-put strategy is revoked, then residents should self-evacuate?
Yes, if they're able to do so.
And if they're unable to do so, then they need to rely on the fire and rescue service to rescue them.
Correct.
Right. Would you agree that that position is inconsistent with the guidance we've been looking at section 15 of PAS 79 on means of escape?
Yes, we didn't finish looking at the section, but you did highlight a couple of sections.
We can look at others if you like.
Well, it might have been useful just to go through the rest of it, because it might have supported my view that implicit in what is written was the fact that we were really talking about non-domestic premises rather than blocks of flats. But if you're happy to take my word for that, sir, we don't need to take up the time of the inquiry looking at further. But there might be further information or further guidance that would simply support my view that that was implicit.
So you say, do you, that within PAS 79, although it expressly referred to as applicable to high-rise residential blocks of flats,
yes,
nonetheless it was implicit in section 15 that the means of escape part didn't, at least so far as concerns vulnerable persons.
At least as so far as concerns arrangements for evacuation of vulnerable persons by people on the premises. Correct.
Now, you told us yesterday you'd written the 2007 edition of PAS 79.
Yes.
And you wrote the 2012 edition, published in August 2012. When you were writing PAS 79 2012, were you also writing the LGA guide?
No, we wrote the LGA guide in the first part of 2011.
Yes.
And we wrote PAS 79 2012. I think you told me, sir, it's published in August.
August
so
2012.
Normal period for writing a PAS, I'm not sure when we started, but the normal period for writing a PAS is not more than 12 months and sometimes less if it's a revision.
Right.
So we wouldn't have been writing the two simultaneously.
My question really is why they're not consistent. Why did you not seek to bring PAS 79 into the 2012 edition in line with the LGA guide that you had written the previous year?
Yeah, that's an interesting point, sir. The general focus of fire safety and enforcement of fire safety and fire risk assessment had not previously been on blocks of flats. What you have to remember, sir, is before 2006, blocks of flats weren't even within the scope of fire safety legislation. So the Fire Precautions Act 1971 never applied to blocks of flats. If you want to be pedantic, there was a power to issue a prohibition notice on a block of flats, but it was never exercised. So there was no mainstream fire safety legislation applied to blocks of flats until 2006. Government chose to incorporate blocks of flats in 2006, not because of concern about people dying from fires in blocks of flats. They were concerned about people dying from fire in blocks of flats, but because the people were invariably dying within their own flat, the fire safety order couldn't do very much about that. But community fire safety efforts by the Fire and Rescue Service. Non-legislative activity most certainly did. So when blocks of flats came within the scope of the fire safety order, there was no vigorous enforcement of the fire safety order from 2006 onwards. The focus was, and quite properly was, on hotels and HMOs and places where the fire safety order could make an impact on life safety. Sorry if this is sounding like a long answer, but I can't think of a shorter one. So the view taken was, well, we, the enforcing authorities, never had any powers to enforce in blocks of flats ever before, and there were no bodies on the streets, as it were, at the time because of that lack of enforcement. So why do we need to vigorously enforce now? I'm not saying they didn't enforce. I'm saying they didn't vigorously enforce. And blocks of flats in Scotland remain outside the scope of fire safety legislation. And again, they do not have deaths from fire beyond the flat of fire origin. In fact, a study done by Scottish Government, without digressing too much, and I'm trying not to, a study done by Scottish Government showed that in the last 10 years, there has not been a single death in a block of flats beyond the flat of fire origin. And now Scottish Government are going back 20 years to see if they can find one death beyond the flat of fire origin. The people who die in the flats. So the fire service were not vigorous in their enforcement. All of that changed with Lakenal House in 2009, but that didn't happen until 2009. And then, to our horror, 6 people died beyond the flat of fire origin. And the interesting thing about these 6 deaths, and the terribly frustrating thing about these 6 deaths, is they probably could have been prevented by better resident engagement and better information to residents. And that's frustrating because we've been saying that for 20 years, that a really important part of fire safety in blocks of flats is engagement with residents. So everything changed after 2009, and it went almost from the sublime to the ridiculous, where some fire authorities, I don't mean ridiculous in the sense of it being a bad thing to do, but it went to the other extreme. So some fire authorities were doing nothing else for a while than enforcing fire safety in blocks of flats. But that was done with such urgency, there was no time to train the officers. And they hadn't ever been in blocks of flats enforcing in general before. And so they threw officers out at blocks of flats. Risk assessors were all called upon to go and look at blocks of flats after 2009, but with no appropriate guidance, because the sleeping accommodation guide was not appropriate. The sleeping accommodation guide was limited to blocks of 4 stories in height. So they couldn't use that. And so they weren't told what to look for. And so there were quite ludicrous things, absurd things being asked for. One fire and rescue authority required newly built blocks in their county to have fire alarm systems installed. And they'd only just been built under building regulations without a fire alarm system. And risk assessors were just as guilty of the same thing.
Mr. Todd, I'm so sorry. I did ask you an open question?
Sorry.
But I think I'm getting more of an open answer than I'd bargained for.
I'm sorry, sir.
I just wondered whether you might be able to help me explain why it was that PAS 79 2012, August 2012, wasn't brought into line with the LGA guidance the previous year.
That's what I was trying to tell you, sir, about taking a long time about it. I appreciate it.
I don't want to be rude, but is there a nutshell?
In a nutshell,
Brazil nut.
In a nutshell, we were in that little period after 2009 where suddenly there was this focus on blocks of flats, but there never had been before. The 2007 PAS 79 had not focused on it. 2012 was just a minor revision, and therefore it had not picked up on the new focus, if you like, on blocks of flats. And that was the purpose of the LGA guide, of course.
I see.
Perhaps I should have given you in that nutshell to begin with, sir. But I just thought it might help the chairman to understand why there was not this focus on blocks of flats until Lakenhall House.
Was there some kind of external, I wouldn't say pressure perhaps, but influence on you when producing PAS 79 not to make too many changes?
No, absolutely not. It would have been in the interests of BSI to have lots of changes.
Yes. So why not, when crafting the 2012 version of PAS 79, make it much clearer that there were parts of it which applied to purpose-built blocks of flats, as the LGA guide had done, and parts of which didn't?
Because we didn't have the visual acuity seen through the lens of hindsight, I suppose.
Right. Now, can I then turn in the 6 minutes before the break to the identification of people especially at risk? Can we go back to your main report for phase 2, please? CTA 6011, page 66. Let's look at paragraph 714. And you say that it's a long paragraph. I don't need it all. You're referring to the 5 steps in the LGA guide.
Yes.
And under 714.2, you say the identification of people especially at risk reflects the requirement of Article 9.7b of the Fire Safety Order that the prescribed information that must be recorded in an FRA includes any group of persons identified by the FRA as especially at risk. In workplaces, hotels, etc., this does include, of course, disabled people, but as discussed in Section 12 of my March 2018 report, identification of disabled people in an FRA for a block of flats creates enormous practical difficulties.
Yes.
Now, it's that last part I want just to cover with you.
Okay.
We've seen your March 2018 report already.
Yes, sir.
Let's go back to that again. CTAR 701, page 121. And get deeper into it. Paragraph 12.6 here, just above the part I read to you, it says this: prevention of fire within a resident's own flat and arrangements for evacuation of a vulnerable resident when fire occurs in their flat are not matters addressed by the Fire Safety Order. Moreover, it is difficult to envisage how this could be otherwise. The responsible person, for example, freeholder or possibly a managing agent, is not in a position to identify the vulnerabilities of every resident, which may change slowly or acutely with time.
Yes.
Now, just is your position, or was the fire risk assessment trade's position, that Article 9.7b of the Fire Safety Order requires that information should be included in the fire risk assessment about any group of persons identified by the assessment as being especially at risk? That's what it says, but
yes.
Did you take that? Did you understand it as meaning what it said?
Yes. It
yes.
does say that.
And individuals who are less able to react and respond to a fire compared to the general population would be persons especially at risk, wouldn't they?
Correct.
Yes. But a fire risk assessment for a residential block, is this right? It was not, didn't need to contain information about those individuals especially at risk because of practical difficulties in collating and maintaining that information.
That's probably very eloquently put, sir, yes.
Right. So is this it, that the distinction, the way of hiving those persons especially at risk off, was because of practical difficulties in collating and maintaining that information? Was that the rationale for not doing them?
Yes, and an understanding that to help these people, and they absolutely should be helped and needed to be helped, I think I put it earlier that legislation was a bit of a blunt tool to deal with it. And people were already dealing with it by identifying those who needed special assistance and having multi-agency support for them, including support by the Fire and Rescue Service.
Was the approach that I've just articulated to you, and with which you've agreed, a common one among fire risk assessors even before the publication of the LGA guide in the middle of 2011?
Yes, I would say so, sir.
Yes. So was the prevailing opinion that it was simply too impracticable for building owners of residential blocks of flats to collect the information, so it would be treated essentially as inapplicable, the requirement?
Yes, that's probably fair comment. It was certainly the view when the LGA guide was written, it was certainly the view of the steering group to whom we were responsible, because I think you're aware, sir, from attachments to my witness statement, we raised this with the steering group and asked them what they wanted to do about it.
Yes. Now, I want to turn then, and we'll come back to that steering group later in your evidence, but what I want to turn next to is Carl Stakes' assessment of disabled persons.
Yes.
But I'm mindful that the shorthand writer has had a very long stretch, Mr. Chairman, and it might be prudent to take the lunch break.
It's 2 minutes to 1. I think that's a good point.
It is.
Yes, thank you. Well, Mr. Todd, we're going to break for lunch at this point. We'll resume at 2 o'clock, please.
With my apologies to the shorthand transcriber if some of my answers were a bit long, sir.
I think as long as you're speaking clearly, she can manage. And you
Thank
were,
you, sir.
so thank you very much. Anyway, 2 o'clock and no discussing your evidence over the break.
Thank you
very much. Right, Mr. Millett, thank you very much. 2 o'clock. Thank you.